The information provided in this podcast is for general purposes only. Individual legal situations vary greatly, and viewers needing individual legal advice should consult directly with an attorney. Eligible ATPE members may contact the ATPE Member Legal Services Department. Hello, and welcome to the ATPE podcast, brought to you by the Association of Texas Professional Educators and covering the hottest topics on Texas educators' minds today.
Hello, and welcome to the ATPE podcast. My name is David George, and I serve as the editor for ATPE News Magazine. Today, we're going to be discussing new legislation regarding the physical restraint of students, and we have two very special guests today to provide both the legal ramifications and how the legislature is handling the issue. We'd like to welcome back a couple of gentlemen to the podcast, Lance Kane, Managing Attorney for ATPE Member Legal Services Department, and ATPE Government Relations Director Monty Exter. Monty and Lance, thanks for being here.
Well, thank you. It's good to be back in the ATPE podcast booth.
In June, the Texas Legislature passed Senate Bill 133. This new law prohibits the physical restraint or use of chemical irritants or tasers on certain public school students by peace officers and school security personnel under certain circumstances. Lance, what exactly are we referring to when we use the phrase physical restraint in this context?
Yeah, context is very important because there are many different ways that an educator can come into contact with a student. In this situation, we're talking about emergency situations where physical interaction is really the last resort. These are not sort of everyday situations where you're guiding a student down the hallway by holding their hand or even reaching out in a sort of a brief emergency situation to keep them from running into the street. We're also not talking about the 9.62 justification where a teacher has the ability to use reasonable physical force to redirect students or to maintain discipline in a group. That's the topic for a whole nother podcast. These are really emergency situations. And they do not include corporal punishment.
How does the Texas Education Code define the lawful use of restraint in schools?
Restraint is defined as physical force or some kind of mechanical device that significantly restricts the student's movement into all or a portion of their body. It really can only be used in an emergency, and that's defined as a situation where there is an imminent serious threat of physical harm to the student or other students, or an imminent serious threat of property destruction. There are also some limitations on restraints. They can only be used sort of to the extent necessary to extinguish the threat. Also, the amount of force has to be reasonable, so you can't use too much force. And then it has to be stopped when the threat no longer is imminent. Also has to be used in a way that really kind of safeguards the other students and that student. And finally, you can't deprive the student of basic human necessities. So you can't, limit their breathing or anything like that.
Are there training requirements relating to the use of physical restraints?
Yeah, the training is a very important part because it will teach the educator not only what proper restraints to use, the techniques to use, but also de-escalation techniques. So hopefully a restraint can be avoided in the first place. A core team on each campus is supposed to be trained. That includes an administrator and then also anyone who might be sort of reasonably anticipated to have to use a restraint. Any kind of personnel that has to use a restraint but did not receive the training, they have to get the training within 30 school days after that. And then, like I said, the training teaches de-escalation techniques and prevention techniques, so to create situations where you might not have to use a restraint at all.
Are there any age limitations for the use of physical restraint?
Mostly no. For most educators and campus personnel, as long as the conditions exist, so there's an emergency situation, a restraint can be used regardless of the student's age. The new legislation that Monty will talk about puts in place laws that sort of limit peace officers and then school security personnel from using physical restraints if the student is under 10 years of age. But there's actually a pretty big exception to that. And the law's new, so we'll see how this plays out. But the exception actually allows those peace officers and school security personnel to use a restraint if the student poses a serious risk to themselves or others. So looking back at the definition of emergency, that's pretty similar.
What are the legal requirements for Texas school districts reporting the use of restraint in their schools?
So anytime there's a restraint, the district has to notify the parents in writing. The notification has to be pretty detailed. We're talking about the name of the person who performed the restraint, the behavior that led up to the restraint, the time the restraint started, the time the restraint ended, the location, really any detail that would give the parent information about the restraint to allow them to kind of assess the situation. The data involving the restraint must also be reported to TEA. And so I think that's why TEA has pretty good records of these types of things.
Are there any special requirements for the use of restraint with special education students or students with disabilities?
Yeah, that's a very good question, and I'll throw a little statistic at you. From 2018 to 2022, 91% of all restraints on younger students, so that's students that are in fourth grade or younger, 91% of those were performed on students that were getting some kind of special education services. And that's despite the fact that those students make up less than 10% of the population. So even though the law itself does not really, it's not exclusive to special ed students, that's largely how school districts utilize them. And so from a teacher's perspective, the main things to look at are the students' special ed records and then their documentation. So the individualized education plan or the IEP. And then if a student has a behavior intervention plan or a BIP, those documents might provide guidance on the types of restraints that should be used, maybe the types of restraints that shouldn't be used, and then also maybe particular de-escalation techniques that might work on that student.
Where can educators find specific procedures for the lawful use of restraint in their classroom?
If you have had the training, that's going to probably be your best resource. So you can, remember the training that you had. If you have materials from the training, you can refer to those as a refresher. If you haven't had the training, but you are a teacher that might be required to perform a restraint at some point, it might be a good idea for you to get in touch with your administration because that might put you into the category of being on that core team that needs to be trained. Other documentation that might be important to look over are, of course, the students' educational records. If they're a special ed student, the IEP and the BIP. District policies are also a good resource to look at because they might have limitations on what type of restraints that they do and do not want you to use. It might also have procedures on what to do in the case of a restraint, clearing the room of other students, or there might be a particular administrator that they want you to call. So district policies are definitely a good resource. Teachers can also look at their regional education service center. They can provide training and they might have resources available as well.
Let me toss this over to you, Monty. How did the legislature handle the issue of restraint during the last regular session?
So I think to answer that question, it's really good to look at a little bit of the background on the issue, less from necessarily a legal perspective and more from who are the advocates around the particular issue. So dealing with restraint at the legislature is not new. It has come up for several sessions in a row. And largely, as Lance sort of alluded to, it has become an issue that is brought up by the special education community, primarily parents of special education students who really are looking to limit the ability to use restraint in some instances just at all. So restraint is by and large not something that either a parent or an educator is looking to do. It is not the optimal situation. However, we don't always deal with optimal situations in school settings. And so it has been our position, the position of folks like T-Case who represent special education coordinators, that the ability to use a restraint when necessary is an important tool in an educator's toolkit. The simple truth is that there are not an insignificant number of parents of particularly special education students who simply disagree with that.
and think that it is never an acceptable situation to use a restraint. And unfortunately, restraints do tend to be very physical. And because of that, as compared to other things that are going on in public schools, there's more of a track record of injury associated with restraint. And not just of the students. I mean, oftentimes it's actually the educator that gets injured. When you have a 5'2", 120-pound teacher who's trying to restrain a, 6'3", 220-pound student, which happens in high schools, then oftentimes it may be the teacher actually that's injured. But regardless of that, it's that record of injury that sort of has created an emotional scenario around this issue. And so what we've seen are bills that are filed and being pushed by some advocates to, again, just disallow restraint altogether. And we saw those again in this last session. And actually, I think it's really interesting in the bill that did pass, it was aimed, right, at primarily police officers and a smaller cohort of educators. And the interesting thing, I think, or an interesting thing, is that it had some different definitions in it than what are currently in law. And it was pretty clear when dealing with the bill author that with regard to police officers, they actually weren't talking about the same kind of restraint that we're talking about today. They were literally talking about handcuffing students. That's what they meant by restraint as that bill was filed. However, the bill really got usurped by the special education parental community and became a bill about this kind of restraint, or at least the conversation became a conversation about this. Now, we'll say whether it was amendments to this bill or other bills that were filed separately, we actually opposed the outright banning of restraint. While it's not optimal, as I said, it is a necessary tool in the toolkit sometimes, and we were successful at that. But I don't think that the issue was adequately addressed by the folks that were looking to outright restrain or outright banned restraint of students. And so some of the things that we've talked about are issues that'll probably come back up and issues that are important to consider, to think about.
So how do you anticipate the legislature handling this issue moving forward?
Absolutely. So as I said, I do think that it's not an issue that's going away in terms of legislative proposals. Who knows whether or not we'll have any legislative action, but in terms of proposals, I anticipate that outright bans will probably be reintroduced. I think it's really important on this issue in particular, for educators, whether they're special education teachers, coordinators, or just your standard teacher, to really do a thoughtful job of interacting with their legislator or with the legislators who are discussing these issues in particular when they come back up, because there is, I think, a pretty general lack of understanding about what restraint is, why restraint is necessary sometimes, and how to improve the situation. Because again, the conversation oftentimes devolves into, well, we need this tool versus no, we need to have none of it ever. And that's not necessarily the most productive place to be. So, for example, training was brought up earlier. We have a lot of very new educators. We have a lot of people who haven't been in the classroom a long time, and that is an accelerating trend. And so having proper training around some of these very physical techniques is important. It can help prevent injury, both of the students and of the educators themselves. More important, probably even to the training, is ensuring that we have proper staffing levels. A lot of these situations could potentially be avoided or at least carried out in a more safe manner if we had more adults per kids in our classrooms, particularly in the situation where you're talking about special education kids. Trying to deal with too many kids at one point in time particularly for an inexperienced educator, is a recipe for things escalating beyond the point where they can be de-escalated with simple conversations. And so that's certainly one thing to look at. And then again, I think it's going to require teachers to really get involved in terms of explaining to legislators why it is necessary for them to have this ability, and how this ability, even though it has some inherent risk, is safer than not having it at all whenever it comes back up. And as we continue to have those conversations, we will work both to support the rights of educators to have a safe environment, which includes being able to utilize these techniques. And we will also continue to try to work with groups of folks who are concerned and wanting, rightfully so, for their students to be safer in public school systems, and ensuring that we can come to the table together to try to bring solutions that benefit everyone, as opposed to simply gridlock up at the Capitol.
Lance, is there anything else educators need to know?
Yeah, I would echo some of what Monty said, because a lot of it is a combination of these factors, with the staffing and with newer educators coming into the fold. And also a big part of it is coming back from a summer break. A lot of behaviors have sort of regressed. So there can be a time period where the teachers are sort of learning the students and learning how to deal with them and learning to de-escalate situations. So that will hopefully get better as the year progresses. But yeah, this is not something that an educator wants to do when they go to school. They do not want to have to be in a situation where they put a teacher in a physical restraint. So focus on the training, any resources available, be in touch with your administration, and really be familiar with those student special ed documentation or documents, so you are familiar with any particular aspects of that particular student that you might need to pay attention to.
Well, thank you, Monty and Lance, both of you, for joining us and so eloquently explaining all this information to us today. As always, if you have any questions or feedback, you can send those to comm@atpe.org. That's COMM@atpe.org. And we encourage you to subscribe to the podcast as well as leave us a review. Thanks again for being here, and we'll see you next time on the ATPE podcast.
Thanks for listening to the ATPE podcast. For more information about becoming part of Texas's largest community of educators, please visit atpe.org.